Welcome everyone to an information briefing by the House Committee on Judiciary and Hawaiian Affairs. It is Friday, March 1st, and it is 2:08 p.m. in the afternoon in conference room 325, and we're also running this informational briefing by video conference. This is an informational briefing specifically for the purpose to discuss the mechanics of record clearance of the record clearance process in Hawaii and learn about the best practices used by other states. The briefing will include presentations by two entities involved in the expungement and sealing of criminal records, the Department of the Attorney General and the Judiciary. It'll also feature experts from outside of Hawaii who have worked with other states on their state-initiated record clearance initiatives. And I want to thank everyone, all the participants, for being here today, and I want to thank everyone who's watching because this will be a very useful information briefing so that we can all better understand what this process is. And if there are some changes that we need to make, statutory authorities and other things to make the process work even better. We'll be hearing for the first half hour or so from the Department of Attorney General, the half hour after that about from the Judiciary, and then after that we'll hear presentations from a couple different groups that are involved with record clearance, both here in the state and in other states. And then we'll go to some questions from our committee. So first up, we have the Department of the Attorney General, who will give us some presentation about how things work here. And so I would ask Phil Higdon, Administrator of the Hawaii Criminal Justice Data Center, to come on up.
Thank you, sir.
Thank you.
Good afternoon, Chair and Vice Chair. My name is Phil Higdon. I'm the Administrator for the Hawaii Criminal Justice Data Center. We are a division within the Department of the Attorney General. And the Data Center, even though I don't have a PowerPoint screen of this, I think it's important to know that the Data Center, which we refer to ourselves, that we manage 7 statewide programs. And you'll hear me talk about two expungements in another program, but the first being the Criminal Justice Information System, which is the CJIS of Hawaii. You'll hear me refer to CJIS. We also have the program of the statewide Automated Biometric Identification System, the Hawaii Integrated Justice Information Sharing Program, which is HIJUS, we have spoken about before, the Criminal History Record Checks. We serve as the state point of contact for the Federal Bureau of Investigation's Criminal Justice Information System services, and we're the statewide sex offender registry, as well as we manage the expungement program. It's important to know that CJIS Hawaii is the automated statewide information system that collects, maintains, and disseminates adult criminal history record information for those arrested, fingerprinted, and photographed. Currently, we have over 636,000 offenders within CJIS and 3.4 million charges within CJIS. CJIS Hawaii is used to provide access to timely and accurate criminal history record information for all authorized purposes, including public access to conviction-only information, and to conduct criminal history record checks on individuals subject to such requirements by law. We have the authority gives us 831-3.2 gives us the authority to expunge records of arrest. Data Center is only authorized to expunge arrests that occur in the state of Hawaii only, no other states. So we're only expunging state of Hawaii information. There's 2 types of expungements that we conduct. One is full and one is partial. And if I can explain full expungements really quick, it erases all the arrest information. Information is deleted from the Data Center systems. The individual, the applicant, is provided an expungement certificate, mug photo, and fingerprints if they're available, and we return them to them. We also have a partial expungement, but that doesn't erase all the arrest charges from the arrest record. It only qualifying for arrest. So if I may, if an individual gets arrested, he's arrested on 5 charges. 4 of those, they file those charges, but the one they don't, let's just say simple possession of marijuana, that simple possession of marijuana is expungible, but we are unable to take the fingerprints and mug photos and give them back to that individual because they're associated with the 4 other charges. So we call it a partial. It's also qualifying arrests and charges are expunged within 120 days. I can tell you that you'll see a number here in a few minutes that we're well below that 120 days. So the screen that you're seeing now is a high overview of the expungement workflow. We receive our expungement individual receives the application and the processing fee. They review the criminal history for final disposition. And once they determine whether the expungement it qualifies for an expungement or not, then they decide what they're going to do. So if the applicant's request for expungement of arrest and charge doesn't qualify, we send them a letter and we return the fee is $35 and we return $25. We have a $10 processing fee that we keep, but we return the other $25. If it does qualify for an expungement, we create an order that we send to the arresting agency, letting them know that the individual qualifies for an expungement, and we're asking them to turn over any mug photos or fingerprints that are associated with that arrest. It takes about 30 days for us to receive that information from the law enforcement agencies, and once we do, then our expunger goes in and removes all that information that can be expunged from CJIS Hawaii, and it deletes it from our other systems. Once she does that, our expunger, then we create and send a certificate and fingerprints and mug photos to the applicant. So some of the facts, expungement facts, that all arrests that qualify for expungements will be processed and there's no additional fee or applications are required. There's other states, I've done some research, and other states require multiple applications, multiple fees to expunge if you want additional arrest expunged. We receive an application and the individual may say, I just want this marijuana, this theft charge expunged. My expunger goes in, she reviews everything, the entire record, and determines if there's any other charges that can be expunged. And we do that with no additional fees, no further applications. We do, however, expunge certain convictions, but only by court order. So if we receive a court order from the judiciary, we will expunge that information as well. Like I said, expungement certificate and the physical mug photo and fingerprints, if they exist, they're returned to the applicant if the expungement is granted. If an individual wishes to review their criminal record, arrest and convictions, we have to verify their identity. So to do that, we require them to fill out an application. There's a processing fee. We fingerprint them to verify their identity, and then we provide them their entire, what we refer to as a rap sheet or their criminal history that will show the arrest and convictions. So I know there was testimony in another bill that said, can a phone app be created so one could just get on the phone and see what their arrest records are, but there's no way to verify that. So we're required to verify the identity. That's important to us, that the arrest information is confidential. The state of Hawaii is not an open record state, which means we can only provide conviction information. The arrest information is limited to only law enforcement and then a select few non-law enforcement agencies. So arrest non-conviction information is confidential, like I said, and can only be released by statute for three specific purposes. And as you can see, for the court or of law or agency preparing a pre-sentence investigation, an agency of the federal or state government that is considering the subject person for a position immediately or directly affecting the national or state security, or law enforcement agency acting within the scope of their duties. Now, 846 2.7 of the state statute allows 52 other entities to receive non-criminal information. They're not for non-criminal purposes. Those range from the police departments, fingerprinting people to determine suitability to have a firearm, to carry a concealed firearm, for schools that individuals are working in close proximity of children and vulnerable adults. There are I know that there may be this misconception that people can look at somebody's arrest information to determine suitability for housing or to be provided, to determine if they're going to be able to be granted access to the university or another school. That is not the case. That is not the case. There's 52 entities right now that can receive arrest information for non-criminal justice purposes. So the average number of applications that the data center receives is approximately 1,440. We approve approximately a little over 1,080 a year. And the average number of days to an expungement to get completed, that we send it out in the mail, is 36. So we have 120 days, but my expunger is very capable of getting that done in a very timely manner, and I have to commend her for that. She does a good job. So the average number of applications that are denied yearly is approximately 360, and that can range from we receive the wrong form of payment, we don't take personal checks, no payment is provided to us, or they don't qualify at the time. So our fees, $35 for their first-time expungement. If somebody has something expunged and a year later they want another arrest or charge expunged, we charge them $50. As I said earlier, there's a $10 non-refundable administrative fee if they don't qualify, and if so choose, they want a duplicate expungement certificate, we charge $20. Those fees go into our revolving fund, which currently pays for half of my employees' salaries and operational costs, not by general funds, but by fees we collect from expungement and fingerprinting services. I know there's been a lot of talk about automation and automatic. I think we're all understand now that nothing's automatic, but we can certainly automate quite a few things. But there are things that we just cannot automate during the expungement process, and that takes research. So when my expunger gets an application, they have to manually research the criminal record. They have to determine if there's a disposition, not only from the law enforcement, but from the prosecutors as well as the court. If there is no disposition, then they have to contact the agencies, try to get the reports, try to see what the outcome of the case was before they can make a determination whether they qualify or not. We also have to manually confirm that there's fingerprints. There are times when individuals are arrested and booked in that they're not fingerprinted, and they're given a different identification number. So we have to go in and determine if there's fingerprints. They may have been stuck in the system and we never retrieved them. They were stuck in the system of the law enforcement agency, so we're having to reach out to them to make sure, hey, you have them or not. As well as we have to determine if there are any civil fingerprints of the applicant, and we have to manually disassociate that criminal information from the civil fingerprint. So those 4 bullets that I talk about, those are things that take a human being to research and look at. We just cannot automate that. So there's some things that we have worked on and have completed. And as you can see, we're sending messages to the FBI now to delete FBI numbers from the NCIC. We're sending messages to the criminal ID section, our CRID section that actually works on fingerprints, to delete arrest information from our system. We're creating expungement certificates. It may seem trivial, but that was a heavy load that was taken off of us, as well as deletion of qualifying arrests from the state's booking system. We're in the process of upgrading our fingerprint system in 4 years, so we're going to be able to automate that as well. So there are plans in place as we speak to automate more things. So that is the gist of my presentation. I appreciate you giving me the time, and I'm happy to answer any questions that you may have later, sir.
Thank you very much, Mr. Higdon. I think what we'll do is we'll continue with our presentations, and then Afterward, we'll take questions from the members of the committee.
Yes, sir.
So next, you were kindly able to arrange for Mr. Roberts to join us. David Roberts, Executive Director of the System for the Electronic Analysis and Retrieval of Criminal Histories, also called SEARCH. Mr. Roberts, if you could please come on up, introduce yourself, and how is it that you've been working with the state and other states on this particular subject matter?
I'll be happy to do so. Thank you very much for having me today. My name is David Roberts. I'm Executive Director of Search Group. We are a consortium of the states. We have one member from every state. They are typically the directors of the state criminal history record repository, like in Hawaii with the Hawaii Criminal Justice Data Center. Leanne Moriyama was our member for many, many years before her retirement, and Chris Young before that. And we have representatives in just about every state in the nation. All states have criminal history record repositories. We are a private nonprofit consortium. Our only members are those state repository directors, and so not our exclusive focus, but our principal focus is on criminal history record systems. How do you make sure that they're complete and accurate and timely? And Hawaii should be very proud. You've got one of the best criminal history systems in the nation. You've got a lot of disposition reporting. Many states struggle with making sure that they tie the initial arrest, which is a fingerprint-based arrest, to the court disposition. Hawaii is in the 85 to 90% of all arrests have final court dispositions in them. There are about 10 states in the country that have 80% or above. We've got a dozen states that are below 50%, and everybody else is in between. So there's a lot that goes into that, and you all have done just a remarkable job in maintaining good, solid quality data. And it's accessible and researchable, which I think is also very important. It allows your state to be able to generate the kind of figures that Phil was talking about a minute ago, and to be able to identify those processes instead of referring to it, as Clean Slate often does, as automatic record clearance. There's nothing automatic about it. It's usually a time-consuming, difficult process to go in and identify all of the different eligibility factors to determine if someone is actually eligible to have their records sealed or expunged or set aside or vacated, or however their states vary dramatically in the range of terms they use for records relief. As the handout that Sean provided at the beginning shows, most states, there are 12 states who have now passed clean slate, statewide clean slate laws. And those states are at all different stages of planning and implementation. It is a very complex process to go through. And one of the reasons it's so challenging is states are typically clearing, I'll just use the generic term of clearing the record, whether it's sealing or actually expunging. And when we say expungement, we usually talk about actual physical destruction of the record. We're encouraged by the fact that in Hawaii, the record is expunged, it's removed from the record-keeping system, but it is preserved in a secure file, and that's important to be able to do research on this in the long term, to understand the impact of redemption and what happens to people who have had their records sealed or expunged or somehow not disclosed broadly. As I say, most states, when they are adopting clean slate, have a very complex, they've identified what offenses it is for. It's usually not only for arrests that result in non-conviction, and that is arrests that result in a plea and a finding of not guilty or dismissal or some other discharge without a final conviction. Many states already authorize sealing, expunging, or destroying those records because there's no formal conviction. And it is at both the adjudication level, so it can be for a single arrest and adjudication, as well as at the record level where you would seal the entire record of the person. Those states, the eligibility criteria are very, very complex and difficult to accomplish. And so states typically, we've got 3 states that have actually implemented clean slate and are up and operational and clearing records. Pennsylvania has been doing it since 2019. They really got underway in 2020. Excuse me. They have since sealed 44 million records. And those are actual adjudicate, I mean, there are only 12 million people in the state of Pennsylvania. So when we talk about sealing 44 or 45 million of those are specific adjudications. So like Hawaii, they can seal multiple charges within a specific record. They had some very strict limitations in terms of eligibility criteria. And in many states, it's this way, and that is you can only seal your record, or the state can only initiate the sealing of your record or the expungement of that record after you have completed your entire sentence. That means you have to serve your entire sentence, you have to pay any fines, fees, restitution, and you have to have served a waiting period. As the form indicates, the waiting periods vary dramatically from a year to 3 years to 5, 7, 10 years in some respects. And it is only for certain kinds of offenses. And it's not just the arrests that don't result in a conviction, it's arrests that result in conviction, but they limit the nature of those offenses. It is typically lower-level misdemeanor offenses, non-violent offenses, non-sex offenses, but even some felonies, if they are non-violent offenses, are eligible after a suitable waiting period. And the waiting period, as I said, only begins to toll once you have actually completed your full sentence. Michigan is in the same respect. I think Michigan by now has sealed about 1.5 million records, and Utah has sealed hundreds of thousands of records. In each one of those three cases, it took several years to actually implement that process. As I say, it's not automatic in any respect. It means tying together court dispositions, and court records are case-based. They're not person-based. They're case-based records. The repository are fingerprint-based records, and those are fingerprint-based person records. So it becomes a real challenge to tie those court records and specific court adjudications back to a specific identifiable individual. It means, and states who have unified court systems where all the courts are using a single case management system, it's usually significantly easier for them because you're only interfacing with one court system. But you still have to tie those records, and there has to be some kind of an offense or arrest tracking number that can relate back to that SID number. That's the fingerprint-based record of the criminal history repository. Determining whether someone has paid their fines and fees becomes a very complex topic. The repository typically doesn't have access to that. Courts have access or may have access. They may manage it. Oftentimes they don't. It goes to a different agency or that handles the fiscal side of that. Pennsylvania found after the first year of clean slate that they were passing over a number of people who were otherwise eligible but who had outstanding fines and fees. So they changed their law and said, we're no longer going to consider fines and fees. You're still liable for it, but we will not withhold clearing your record based on outstanding fines and fees. That made 9 million additional records available for sealing as a result of that. They still had to pay restitution before they became eligible, and actually before the waiting period time begins to toll. And in Pennsylvania, they have simply said, we're not looking at that. We're only looking at your waiting period, and we're not going to consider outstanding fines and fees. In Utah, I think they still looked at fines and fees. They were nevertheless still able to seal that. But in each of those cases, in each of the states, it took 2 or 3 years to build the systems and build the process so we could really understand and implement clean slate. So it's typically a fairly lengthy and expensive process. In Michigan, the governor set aside a budget of $19 million to actually do the implementation of clean slate. As I say, they have managed it, they've done very well, but it's a long and complicated process. I think, at least from what I've seen from the legislation that's being proposed in Hawaii, you've made it significantly easier in a lot of respects. First of all, you're looking principally at arrests that result in non-conviction. And so clearing those records becomes much easier because you don't have a conviction, so you don't have to work on the waiting period and everything else. You also, you do allow expungement of some records of conviction, but those are for lower level offenses of operating a vehicle under 21, sentencing for first-time drug offenders, first-time drug offense prior to 2004, and sentencing for first-time property offenses. But those typically don't have, some of those I think have a bit of waiting period associated, and it depends on the adjudication. If it's a deferral from the prosecutor, I understand there's a certain waiting period for those kinds of offenses. But the fact that the majority of cases you're talking about are arrests that have a non-conviction as the final adjudication in the case makes it much easier. I think the fact that the repository has such high-quality data and that they're able to query that data, identify eligible cases, and that it can be a state-initiated process makes things easier as well. You also have few of the limitations that most states have in terms of saying, if you have this kind of an offense in your criminal history record, you're not eligible to seal anything. There are some states that say, if you've got this kind of a background, you're not eligible to have any record sealed or expunged. Typically, states do, as I said earlier, if you have an arrest that resulted in a non-conviction, those records are often treated completely separately and can be expunged and deleted because you don't have a conviction on your record. As Phil said, in most states, as well as in this state, the arrest record is not broadly publicly available, which makes perfect sense. There's been no adjudication there. I think we did do some general figures. Phil and his staff were able to pull some figures together, and I think it was important when I first came out and was talking with Phil about it. The 50,000 record figure was thrown about, that there are 50,000 records that are eligible. And there are this form that I think Sean passed out, there are 52,639, 712, 1249 adjudications out there or arrests out there that are potentially eligible. That relates to 36,000 people. So part of the reason for pulling these figures together was to say, we're not talking about 52,000 people. We're talking about 52,000 charges, 36,000 people. 87% of those people have records with other offenses in them, and 70% of those 36,000 people have records with other adjudications, actual convictions in their records. So the idea was not to minimize it, it was simply to say, let's make sure we've got a level set on the numbers we're actually talking about. We also looked at those 36,000 people, how many had a single charge of a 712. 1249, and that's 74% of those people had a single charge. So the importance of that is if you are able to seal or expunge that record, that adjudication, that expunges the entire record. And there's some real benefit to that. That's where I think if you've got someone who has a compound record where they have some arrests for this with not convictions and they have other convictions of more serious offenses, they're still going to have a record. So it's still going to have some collateral consequences attached to it. The fact that you've got so many people with a single eligible charge, and those are people, not just records. So many people with a single eligible charge means that 74% of those people, after that record is expunged, are not going to have a criminal record at all. And so they really avert all of the collateral consequences that are associated with it. We've got some other figures in there in terms of the folks who have multiple charges and how that look, and as well as the kinds of convictions for the 25,602 offenders who have other convictions, the nature of those convictions, as well as some numbers on the total number of expungements that are handled. These are not just the 712 expungements, those are all expungements, but we thought it was nevertheless important. And these figures were really kind of summarized by Phil, the fact that you had 1,409 expungement applications in 2023, 16% of those were denied, 84% of those were actually issued, the certificates were issued. 74% of those were full expungements. So that destroyed, that destroyed the entire record. So about 25%, a quarter of them were partial expungements, so that there were other charges that are still there. But it at least gives you some scale of the volume of cases you're handling. As I say, at Search, we don't take a position in favor or opposed to any piece of legislation, but we do want to at least make sure you have good, solid quality data on the nature of the information systems, the complexity and the challenges of linking records. As I say, Hawaii is in an enviable position of having a unified court system, of having good, solid court records, a very, very high quality criminal history database, and the ability to do this kind of analysis and give you the kind of quality data. You don't suffer with all of the waiting periods that most states are working on, and you have a limited scale of offenses of conviction that are actually eligible. So I know we're going to ask questions at the end. If there's any questions immediately, I'm happy to respond to those.
Thank you very much, Mr. Roberts. I think we will continue with our presentations and then go to questions at the end. I think it'll benefit all of us to hear from all the different parties first, and I think we'll have questions for everybody as we go forward. So thank you very much, Mr. Roberts. Okay, next, I think we're going to be hearing from a team from the Judiciary. First up, we have Michelle Acosta, who is Deputy Chief Court Administrator for the First Circuit. And I want to commend all the presenters today for providing us the presentations in advance. We have posted them so that people who pull up the hearing notice for this informational briefing would be able to download the informational briefing materials and review them at your own time. So there's a number of folks here from Judiciary, but we'll first start out with Michelle Acosta, Deputy Chief Court Administrator for the First Circuit. Welcome.
Thank you.
Please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. Again, I'm Michelle Acosta. I do have colleagues here with me who were listed in the notice, but they will be available for questions at the question and answer portion.
I could mention who they are. Thomas Berger, Supreme Court Staff Attorney, Mai Van, Director of the Information Technology and Systems Department, and Dana Nakasato, Judiciary Information Management Systems Specialist. So I appreciate everybody being here, and we'll turn it back to you, Ms. Acosta.
Thank you.
There you go.
Okay, thank you. I do want to add 1% to
Oh, please.
that. So I do have Ms. Jennifer Awang, who is our Criminal Division Staff Attorney for the First Circuit. So she is available for questions later
Excellent.
as well. Thank you.
Thank you.
Thank you very much for allowing the Judiciary to take part in this discussion today in this briefing. We very much appreciate being part of that, this important discussion. The Judiciary is an independent government branch and is responsible for administering justice in an impartial manner according to the law. And as was mentioned earlier, we are a unified judiciary, which we have 4 judicial circuits within the state. The First Circuit is the city and county of Honolulu, island of Oahu, is the jurisdiction. We also have a Second Circuit, which is the county of Maui. And the Third Circuit is Hawaii County, and the Fifth Circuit is Kauai County. And so I do, while I am from the First Circuit, I am representing the Judiciary in all the circuits today. This afternoon, I will provide a general overview of the court's current process of sealing non-conviction arrest records and expunging court conviction records under current statutory authority. So thank you for allowing me to present right after the Department of Attorney General's, because I think that carries presents the steps soon after the eviction certificate is generated by the Department of Attorney General. So before I get started, and I will remember to move my slides along here. I want to start with making a distinction between arrest and conviction records. Just for everybody, and I know there are several people who have been working in this field for quite a while, so please indulge me in the definitions. Certainly. An arrest is when a person is taken into custody by law enforcement for suspicion of a criminal act, and as described earlier by HCDCJ, arrest records are then generated when a person is booked, and therefore there are records that are generated from there, including photographs and fingerprinting. These records do not become court records until a court case is initiated, and a court case is initiated once a prosecuting agency initiates charges against the individual. In the state of Hawaii, the prosecutor's Attorney General's office will case initiate, and so they do have access to our Judiciary Information Management System, which is our case management system for the Judiciary. They will case initiate there. At that point, a case identifier is generated in our court case system. This court identifier number is different from the arrest record, is different from the SID record. And so this is where we have a different number that's generated. A person who may have multiple charges will be generated under one case identifier number. And so as was described earlier, there may be multiple arrests, multiple counts that may be lumped into one case number. Again, the non-conviction arrest records maybe are really limited to where there is no case that has been generated by the prosecuting agency, or where there is a case and the case results in a not guilty verdict, or the case is dismissed, and therefore there is just a case record, an arrest record, but no conviction. And for those types of cases under HRS Chapter 831-3.2, only the Department of Attorney General has authority to expunge those arrest records. In a conviction, this is where a verdict of finding or finding of guilt in a criminal trial, or a plea of guilty or no contest to a criminal charge issued by the court, that is the conviction. The conviction record is part of the court case record, and it's among many other things that are contained in the court case record, including the complaint, any kind of pleadings that have been filed or motions that have been filed in that case. The conviction record is part of that. Under certain statutory provisions, which are listed here and mentioned earlier, these are the only, the court has authority to expunge that conviction record and not necessarily the court case, but just a conviction record under these HRS chapters. So from there, I just wanted to make it clear that the court has ownership and a responsibility for maintaining the court case record, and that the law enforcement agencies and HCJDC has ownership and the authority to make changes to any of their court record or to their arrest records and criminal record. So the process, once a defendant or an accused, an individual has applied and received a expungement certificate from HCJDC, the process is for the individual to submit a written request to the court to seal the record. And this is by way of a letter and that's sent to the court. The court does a review of the request, and we do try to look for a case ID number. We make sure that there's the correct name, there's no conviction, and the case is not currently active. Those are the qualifiers under the HRS 831-3.2, subsection F. The process for this does create a manual research on our part to make sure that we are identifying the correct record and that we are identifying the correct individual. So once that's issued, a court order to seal is issued, and that order is sent to the petitioner or the person who has requested for the seal. Just to make some clarifications, once this is done, we are able to seal that case information from public access if it is one arrest record, one case record. So as was mentioned earlier, if it's compounded, there's multiple arrests and multiple charges and multiple counts, and only one or two of those charges is expunged, the case will remain open and public access is available because there are other counts that are still active in the case. So, as an example of what I talked about earlier, about what is submitted to the court with a request to seal a record, what I'm showing here is a sample letter and a sample of the expungement certificate. Both these documents are necessary to be submitted to the court for us to take a look at, the court to review. At that point, we do highlight in the sample letter that a case number is necessary or helpful. A lot of times, the court will only get a letter saying, I have received an expungement certificate, please seal my record. At that point, there is a lot of manual work to search our records to make sure that we are identifying the right person and the right case number. to effectuate the sealing. As an example here, the expungement certificate provides us the offense and the date of arrest. And sometimes we get the name, the full name, and we're then having to generate the process, or conduct the process of researching and identifying the correct record and person. In 2019, we developed some resources through the Judiciary's Hawaii State Law Library system. This is the Supreme Court Law Library. If you Google how to seal my record on Google, this information will show up. It is also linked on the Judiciary's website. As you can see here, it is very specific to non-conviction records. So it is available here. And I'm just showing you a few sample pages of the FAQ that you're able to take a look at. This is public information. We do emphasize in our FAQs that it is important to find your case and your case number so that we can identify it quickly. So we do walk through that. We also include information that there is no cost to the petitioner, to the applicant, to request to seal their expunged record. As mentioned earlier, there are certain statutory provisions that authorize the court to expunge a conviction record. They are listed here. It's cutting off on your screen, so I'm not sure if I can make this a little bit smaller, but it was mentioned earlier that it is for operating a vehicle after consuming a measurable amount of alcohol, persons under the age of 21. Sentencing for first-time drug offender prior to 2004, sentencing for first-time property offender, and commercial sexual exploitation. So these are the only statutes, sections of the HRS that authorize the court to expunge a conviction record. Again, for step one in the process is that a written request has to be submitted to the court, and usually this is done through a motion. Once that's submitted to the court will go through an eligibility review. Taking, for example, HRS 291E-0064 subsection E, this is operating a vehicle after consuming a measurable amount of alcohol for persons under age of 21. The review will, for the court's review, we will take a look at to see if this offense is a first conviction under the statute, which is a requirement. That we also will look at to see if the defendant has no prior alcohol enforcement contact, meaning that there has been no administrative revocation of a license, or license suspension for refusing to test for alcohol. So these are not necessarily arrests or convictions, but we do take a look at that because they are a requirement under the statute. And then we do have to take a look at whether or not the defendant has attained the age of 21 and that the defendant has fulfilled the terms of the sentence imposed by the court and that the defendant has had no subsequent alcohol or drug-related enforcement contacts. So these are the requirements in order for the court to issue an expungement on that particular offense and conviction. Once that's done, the defendant is provided with the court order that expunges, and that, again, only expunges the court record. It does not expunge any other other records that may be out there that are housed, for example, with the HCJDC. The defendant is then it's on the defendant to bring that expungement order to HCJDC and present that so that their arrest records are then expunged on their end. For the court side, the public information, as many of you may be familiar, is through eCourt Kokua. And you can go online and take a look at, do a party search and name search at that point. If there is, again, one arrest record that generates a case record and no other charges and no other counts, we're able to seal that from eCourt Kokua from the public access. However, again, if there's other charges, other counts, we're not going to be able to seal that entire case from public access. So as an example, here, when you search on eCourt Kukui, for example, for John Doe, and the traffic crime, again, arrest record, one case, one count, we're able to seal it. So the second, the bottom portion of the slide, as you can see, is when the court has sealed, is not going to show up on a name search on eCourt Kukui. There are, aside from what I mentioned, that if there are multiple charges and multiple counts that, and only one or two have been expunged, the limitation is that you can still search for it on our eCourt Kukui, the public-facing portal. The other system limitation is if there are multiple defendants in a case. And so if you have one case and there are two defendants, and you're only expunging record for one of them, the case is still open and active, and therefore that is still open and available for public access. The other system limitations is that if for example, here, John Doe is John S. Doe, John Sam Doe, John Jr., Sr., different party IDs may be associated with that individual. And therefore, it may, part of our search and challenges is identifying is this the same person. So those are limitations that we have in our current system. Other limitations that we do have is that, as was described earlier, while we do have some interfacing with HCJDC with our records and dispositions, makes it challenging to search some of these records. And so we're not fully integrated as some of the other jurisdictions who may have implemented clean slate initiatives. So again, that is a challenge when our systems are not fully integrated or integrated in that way where it makes it easy for us to search the records and the status of those arrests and court dispositions. I can share some numbers, at least for the First Circuit District Court, where we have a lot of the requests to seal under HRS 831-3.2 and also more commonly under HRS 291E-0064, which is operating a vehicle after consuming measurable amount under 21. We average, I think in the last 3 years, have had 600 requests to seal and also to expunge. And we're averaging about 76 to 80% granting of sealing and expunging those records. The reasons for denials can vary. It could be that they're not eligible. It could be other reasons that does not qualify them for a sealing or expungement at that time. This is pretty much my presentation on the process, the current process. Again, I on behalf of the Judiciary, we are very thankful to be part of this conversation. We understand that it is an important issue for the community, and so therefore we are grateful to continue the conversation. Thank you.
Thank you very much, Ms. Acosta. I appreciate that you understand how important this is to the community and to the committee, and that we're all aiming toward the same goal of trying to help people with their own redemption. I think I appreciate and acknowledge that. Well, I think what we'll do is we'll move on to the next presenters, and then after that, we'll have all the presenters come join us at the table and have a conversation. Thank you very much, Ms. Acosta. So next, we're going to have Jennifer Brown, who is Associate Director and Staff Attorney at Hawaii Innocence Project, who will present to us next. Appreciate you being here.
Just all my technology.
Yeah, get all set up there. and while you're getting set up, I want to acknowledge our Judiciary and Hawaiian Affairs Committee Staff Attorney, Sean Aronson, who really took the lead in putting together this informational briefing. He's the backbone for our staff. We have other staff here as well, Jen He and as well as Reese Nakamura, who work with the committee. And so I want to acknowledge their efforts in putting this informational briefing together. So at this time, let's turn our attention to the presentation by Jennifer Brown with the Hawaii Innocence Project.
Thank you, Chair.
Please proceed.
Thank you. So as mentioned, I work for the Hawaii Innocence Project as the Associate Director and Attorney, as well as Beyond Guilt Clinic at the William S. Richardson School of Law. In both clinics, we do post-conviction relief, so for formerly and currently incarcerated people. And we do that pro bono. So we are pretty much, because a lot of, even the public defender's offices cannot do all post-conviction relief. So we kind of fill in the gaps where other agencies cannot. So we assist with post-conviction relief that could be filed by habeas, but also we do clemency, so pardons, expungements, et cetera. So a couple years back, as the community need for expungements kind of increased, or people were, hearing about clean slate that was being done in other jurisdictions, we decided to do, in conjunction with the National Expungement Week, a pop-up legal clinic at our clinical building at the law school, where we invited attorneys in the community to provide pro bono services to those that were interested in getting assistance with expungements. And so essentially, we had over a dozen attorneys that volunteered at that event, and we also had over, I think, 60 people that reached out to us for assistance. Originally, with that clinic, we were going to do both expungements for convictions and non-convictions. But what we found, and what I'm talking about today is kind of the lessons that we learned from that process, was that it was actually really difficult, even for the attorneys, to understand whether or not a conviction applied. And these are attorneys that went to law school and can read statutes, and they were even having the struggles learning and understanding whether somebody was in fact eligible and could fill out an application. Sorry about that. Okay. So what we kind of learned through our experience in assisting individuals with expungements is there are a lot of challenges. The first challenge is many people are not aware of what's on their record. They don't usually know it's on their record, or that there's an issue with a conviction or non-conviction on their record, and so they apply for a job and get denied, or get a job sometimes, and 6 months later they find out they have a criminal record, and so then they lose that job. Certain housing will not allow you with certain types of conviction on your record. Many countries actually don't allow you to travel. Canada is one, Japan is one, if you have certain kind of arrest or convictions on your record. So a lot of times people are coming to you in a lot of despair because something negative has already happened and they've been impacted by that. And again, the confusion on the part of the person, because they don't know or were never told, oh, I got arrested, but what do you mean my arrest record? Like, somebody can see that, right? They also don't know that their convictions are even eligible for expungement. And so I know they were speaking about the application process, the one-page form that they had to fill out. But there is a lot of legalese and technical jargon on that form. It kind of quotes some of the statutes, the statutory language, so it is confusing for people to understand even the form and whether or not they qualify. And again, it's also a multi-step process. So you've got to first get your expungement, and then you also have to go through the record sealing process that they've already discussed. And it's also hard for people to obtain the documentation that's necessary to submit with their application. So for example, they mentioned that to get an expungement order, you have to file a motion with the court. That's just to get the expungement. Then you have to fill out the application, and then you have to use that certificate to then go back to the court to seal the record. So it is a multi-step process that I think a lot of people are intimidated by. Also, things that we learned from the individuals that we assisted with expungements is that it's oftentimes cost prohibitive. So we had heard stories from people that had said that they had reached out to an attorney to get them to help them with the process because they didn't understand it. and that attorney quoted them thousands of dollars to do an expungement. We also heard that somebody had actually paid $2,000 or $3,000 to an attorney who then told them they weren't eligible for an expungement, and they actually were. So there's a lot of confusion with that. And then also when we did the pro bono expungement clinic, what we found is that a lot of people couldn't pay the application fee. So I know it's $35 for the first time, $50 for any subsequent, but that was even a really difficult thing for a lot of people who are just making ends meet. And so again, I think the public defenders had mentioned in their previous testimony about expungements that really, they cannot assist individuals with expungements. So that means that people that would qualify for a public defender, so low or no cost legal services, they actually cannot use the public defenders for them to help them get an expungement. And what we also learned through the process of doing this clinic is that attorney training, we were really surprised at how many attorneys didn't understand what an expungement was. And so we basically ended up doing a whole training session for the attorneys that volunteered with us because, again, that process was confusing for them too. And then even when we had attorneys assisting, there still was that question of when is for some of these you have to wait till a certain time period has passed. And looking at a person's court record, while helpful, it doesn't always have all the information that you need to tell somebody whether or not they're eligible to apply now. So those are some of the challenges that we found. And then we also learned a lot of good lessons. So we definitely learned that with some public education is incredibly important. And I think what the data center and the judiciary have put on their websites has been helpful for a lot of people because it hasn't always existed there. So it is a place that they can get that information, but there needs to be, more broader education around expungements and who qualifies. Obviously, attorney training is important, but really it's about helping people that are eligible for expungements beforehand and not at the back end after they've already suffered some sort of hardship. We did, in looking at the numbers that was provided, and I'm a little bit unclear, so I'm just gonna, on exactly what, but I was just kind of doing some math. And if you look at, I think listed here is like 52,639 or something people that might be, or charges that might be eligible for expungement, and that they're processing about 1,400 a year. So if we look at just those that might qualify under 712, 1249, it might take anywhere, depending on which number is the accurate number, in between 25 and 37 years for all of those, based on the current rate that the data center is able to process in the courts too. So that, that seems like it would be a really long process for somebody to get relief, right? And so that's why, we really want to encourage a state-initiated process, some sort of notification system that lets people know when they're eligible, that doesn't require, them reaching out to an attorney or paying an attorney to find out if they're eligible and to help them with that process. And then also, I think too, I know they mentioned, expunging from the FBI database, but we all know that there's so many, especially with technology today, there's so many places that your data lives, and it lives in all of these places. So I think also really letting people know, well, we can do this, but you may need to send that certificate to these other databases that are, known to us, that often employers will check, and that sort of thing. And so I'm gonna leave it to my colleague who's gonna tell you about these amazing things they've been doing in other states.
Thank you very much, Ms. Brown. I appreciate that. We look forward to our questions in just a little bit. But before we do that, we're going to hear from Frank Stiefel, Senior Policy Associate with the Last Prisoner Project. And I look forward, if you could, as you get set up, and you can explain more about what the Last Prisoner Project, let me explain a little bit more about Last Prisoner Project while you get set up. It's a national, nonpartisan, nonprofit organization focused on the intersection of cannabis and criminal justice reform. Frank is a senior member of the policy team, and he provides nonpartisan, evidence-based technical assistance to jurisdictions working to advance cannabis laws that provide retroactive relief. So there's my introduction for you, sir.
Perfect. You saved me some time there. I
Please-
appreciate that, Representative Tarnas.
Please proceed.
Yeah. So good afternoon, everyone. My name is Frank Stiefel. As Representative Tarnas mentioned, I'm a senior policy associate with the Last Prisoner Project. Want to thank you, Representative Tarnas, for inviting us today to participate in the informational briefing on expungement. And what I'm looking forward to doing today is to share information on what we know as far as best practices and evidence-based policies as it pertains to cannabis record clearance. As Representative Tarnas mentioned, the Last Prisoner Project is focused on cannabis-related criminal justice reform. When a state decriminalizes or even legalizes adult use cannabis, it doesn't necessarily mean that every person that has a cannabis criminal record is able to have it expunged. The Last Prisoner Project has worked in Hawaii for the past 2 years to ensure that retroactive relief is provided for those who have been criminalized during Prohibition. Thank you. In 2022, we presented evidence-based policy recommendations that were endorsed by Hawaii's Dual Use of Cannabis Task Force. Our recommendations outline state-initiated processes to provide retroactive relief for individuals with cannabis convictions and led to LPP being named in Concurrent Resolution Number 51 and House Resolution Number 53, which urged Governor Green to initiate a clemency program for individuals who are still under supervision for a cannabis conviction. It is vitally important that states set up effective record clearance processes because of how many Americans are impacted by a criminal record. We aren't talking about a small portion of the population. 1 in every 3 Americans has a criminal record. And when an individual has a criminal record, the collateral consequences linger for a lifetime. It is important to note that a person can have a criminal record even if they've been found not guilty of any criminal wrongdoing. A person can also have a criminal record if what they were arrested or charged for has since been decriminalized or even legalized. An overwhelming majority of states practice some form of retroactive relief for non-convictions, misdemeanors, and in some instances, felonies. Only the federal government, Alaska, Florida, Maine, Wisconsin, and Hawaii lack a coordinated and definitive framework for record clearance. Individuals with a criminal record are often restricted from employment, housing, political participation, public assistance, education, and a myriad of other services and resources that allow individuals to lead healthy lives. For example, individuals who have been impacted by the wildfires in Maui and who have a criminal record may be disqualified from receiving federal assistance. Research shows that shutting people with criminal records out of the labor market costs the United States roughly $87 billion in lost annual GDP. The restrictions of a criminal record not only hinder the well-being of the individual, but they hinder the well-being and safety of entire communities. Record clearance processes promote public safety by expanding access to employment, housing, and educational resources that allow for community reintegration and stability. Empirical data demonstrates that 5 years after benefiting from record clearance, individuals are actually less likely than members of the general public to engage in criminal conduct. Now, in this section, I'm going to go over what the model policy components are for a record clearance process. When I say record clearance, I'm referring to the process of updating an individual's criminal record to remove a specific event like a violation, arrest, or conviction. Depending on the state, the process of clearing an individual's criminal record can be referred to as either an expungement, a sealment, or a set-aside. But in Hawaii, the record clearance process encapsulates both the expungement and the sealing of records. The policy components that I will go over are based on data-driven research and national best practice. While states generally allow individuals to petition the court to have certain records cleared due to cost, complexity, and the lack of legal representation, the vast majority of individuals that are eligible to clear, seal, expunge, or set aside their records never obtain relief. As a result, these individuals that are legally eligible for record clearance continue to be burdened by the collateral consequences of criminal records, including lack of access to meaningful employment, housing, and education. National research shows that less than 6.5% of people who are already eligible for expungement ever have their criminal records expunged, because of the cumbersome nature of the record clearance process. This is why it is important for Hawaii to initiate the record clearance process. Now, I want to be clear. A state-initiated process does not mean that immediate record clearance relief is granted. You cannot wipe a criminal conviction simply by pressing a button. A state-initiated record clearance process tasks the appropriate local and state agencies with initiating the expungement process, as opposed to tasking the individual with petitioning various agencies to have their criminal record expunged. As I mentioned earlier, a person can have a criminal record even if what they were arrested or charged for has since been decriminalized or even legalized. This is why it is important that these state-initiated record clearance processes are retroactively applied to ensure that every person that is eligible for relief actually receives it. The first step of a state-initiated record clearance process is tasking the appropriate government agency with querying the state's criminal record repository to determine the universe of criminal records that are eligible for a state-initiated record clearance process. Once these eligible records have been identified, the state then ushers them through the expungement process. The end result of the state-initiated record clearance process is the permanent shielding of the individual's criminal record from public view and allows the person to act as if the criminal record never existed. I want to note here that when states have passed legislation that have set up these state-initiated expungement processes, there has been a long runway that has been created for agencies to build up the capacity and the infrastructure needed to successfully implement these record clearance processes. For example, in 2021, Virginia legalized adult use cannabis and set up a state-initiated record clearance process for cannabis records. But the implementation start date for the record clearance process wasn't until 2025. Michigan passed legislation in 2020 for the creation of an even broader state-initiated record clearance process for non-convictions and eligible misdemeanors and felonies. And the implementation start date for that record clearance process wasn't until 2023. California, Connecticut, and Delaware also passed legislation to create these broader state-initiated record clearance processes. And again, they didn't mandate that these processes begin to be implemented until 2 or 3 years after the legislation had been passed. So as you can see, it's important to have a start date, but a due date is not necessarily needed. In lieu of a due date, it's important to have reporting mechanisms in place, which I will discuss in a little bit here. Eligibility criteria for a state-initiated record clearance process should be broad, clearly defined, and inclusive of all convictions and non-convictions. Potential criteria for ineligibility should be limited. This means implementing clear guardrails and only allowing the courts, prosecutors, and other state actors that are involved in the record clearance process to object to the clearing of a record on the grounds that that record is statutorily ineligible. It is important that there are no unnecessary hurdles to record clearance. An individual should remain eligible for state-initiated record clearance, regardless of whether or not they have been granted a prior expungement for a different offense, and all related fees should be waived. Missouri provides a great example of what a broad eligibility scheme could look like for a state-initiated record clearance process. Missouri legalized adult use cannabis in 2022 and set up a state-initiated record clearance process for cannabis records, which included most felony convictions. All associated costs were paid by the state as a part of their record clearance process. The broad eligibility scheme that Missouri set up has allowed the state to clear over 100,000 cannabis records so far. I want to also stress that these broad eligibility schemes bring down the fiscal note for implementing these state-initiated record clearance processes. For example, the broad eligibility schemes in Rhode Island and New Mexico ensured that the fiscal note for implementing their state-initiated record clearance process was around $500,000. But it's important to note that both of these states were working to clear a much larger universe of cannabis records than what Hawaii would likely take on. The final piece of the puzzle is creating a state-initiated record. The final piece of the puzzle in creating a state-initiated record clearance process is setting up reporting requirements that can ensure the process is being implemented with fidelity. One way to do this is to have regular status reports that are issued by the agency that is leading the implementation of the record clearance process. As I mentioned earlier, it is important that states have a start date for when they should begin to implement these state-initiated record clearance processes. Due dates are not as important, as unfortunately many times deadlines go missed. This is why regular reporting by the agency that is leading the implementation of the record clearance process is so vital. Reports on the status of the implementation can be issued on a yearly or a quarterly basis and aim to highlight how the state is progressing in clearing all eligible criminal records. This will establish new transparency requirements that allow the legislature and citizens to monitor the state's progress towards implementation. We have seen this be tremendously helpful with the state-initiated record clearance process that we helped to develop in California for people with cannabis records. We worked with legislators in California to draft language for a record clearance bill that required the state's Department of Justice to issue quarterly reports to the legislature, which highlighted how many eligible records each county in the state cleared and how many more eligible records each county still needed to clear. This has allowed the state and other stakeholders to identify pain points for where there needs to be more troubleshooting to ensure that the state is able to clear every last eligible cannabis record. Finally, it is important that individuals are made aware that their criminal record has been sealed by the state so that they may respond accordingly when questioned about their criminal record history, whether that's during a job interview or when applying for public assistance. There are numerous ways to educate the public about their newly sealed record. The state can use billboards, social media pages, educational webinars, or schedule meetings and presentations with community-based groups to spread the word. I want to now talk about how a state-initiated record clearance process for cannabis possession records can serve as a blueprint for further improvements to Hawaii's record clearance system. We know from data released by the Department of the Attorney General that there are approximately 50,000 records for cannabis possession. This means that thousands of people in Hawaii are impacted by a criminal record for cannabis possession, even though that offense poses no risk to public safety. The fact that these individuals have a criminal record is already costing the state money because they are being restricted from having jobs and cannot receive federal assistance due to the fact that they have a criminal record. I want to note here that in our experience in working with states, the identification of these records is one of the biggest challenges that a state faces when trying to implement a state-initiated record clearance process. The fact that the Attorney General already knows the universe of these records is a tremendous first step in successfully implementing a state-initiated process. The second piece I want to highlight is that the possession of cannabis was decriminalized by the legislature in 2019. So we're talking about criminal records that are already eligible for expungement. Research shows that these individuals who have cannabis possession records do not pose a threat to public safety, and that expunging these records would actually increase public safety. We believe that HB 1595 will allow Hawaii to pilot a state-initiated record clearance process on an already known universe of cannabis possession records. The bill that Representative Tarnas has introduced does not get ahead of Hawaii on the question of legalization, nor does it rely on Hawaii passing a legalization bill. Instead, the bill aims to create a state-initiated process that would be triggered by the Department of the Attorney General to provide expungements for those with offenses that have already been decriminalized. Most importantly, HB 1595 would close the uptake gap between people who are already eligible for relief under existing law but have yet been able to receive record clearance relief. The implementation of this state-initiated record clearance process can help to illuminate how Hawaii's record clearance system can be further improved so that individuals with other eligible criminal records can actually end up receiving record clearance relief. We saw this in Virginia when the state legalized adult use cannabis and set up a state-initiated record clearance process for individuals with cannabis records. The rollout of the state-initiated record clearance process allowed Virginia to address issues that had gone on for years within their court system. We believe that the creation of a state-initiated record clearance process for cannabis possession records in Hawaii will not only ensure relief for those who have suffered for far too long for an offense that Hawaii changed its mind about enforcing in 2019, but it will also help Hawaii troubleshoot how to make further improvements to its record clearance process. I've attached my contact information here, and I want to thank you again for having me, and I'll stick around for any questions.
Thank you very much. I appreciate the presentation, Mr. Stiefel, and I would like to invite all the presenters to come to the table here, if you could all join together, because I think we'll have questions that will, and maybe we can get some more chairs, thanks to staff to help us out here. And we'll move some microphones around so everyone would have access. You might have to share a microphone. Again, thank you all very much for the presentations. You know, this is a complicated matter, and I can only imagine what it's like for somebody who, you know, is trying to navigate this. So I appreciate that people are trying to explain it in the simplest manner. But maybe we could just start out, you know, asking in the Department of the Attorney General, Mr. Higdon. You know, we talked about Act 159 from last year, and these are, maybe if you could speak to that. You're familiar with Act 159. You could perhaps, if you could describe it in layman's terms about what it's laying out for us, and could you give us some sense of, do you have existing statutory authority to fully implement it, or are there some things that we really need to still do at the legislature?
Well, I don't have the bill in front of me, or the act in front of me. I apologize.
I'll give it to you.
Sure. Thank you, sir. My understanding of the bill or the act was that we were to provide expungement information to Judiciary for the purpose of them removing it from their public website, arrest and/or convictions. As the data center, the Department of the Attorney General, as we read the bill at that time, we thought the lift was on the Judiciary, that it wouldn't affect us at that point. We even had our attorneys review it as well after the fact. But once it became an act and we started looking at it again, and I had our attorneys look at it, we didn't have the authorization to give that expungement information to Judiciary. As I stated in the presentation before, there's certain criteria, certain individuals that get that information. So myself, the attorney assigned to us, we looked at what needed to be done statutorily, and really, to give expungement information to Judiciary is basically a one-liner to be added to amend the statute. Like I said, I think there was some oversight, oversight on our part, and maybe as well on the Judiciary. I don't know. I'm not going to speak for the Judiciary. It was a misunderstanding of Act 159. But I think it is doable now if we can get the statute amended to give us that authority to give that information to the Judiciary, sir.
Thank you, I appreciate it. And I think the legislature can take its share of the blame for not having a complete bill that was implementable. Maybe I could ask Ms. Acosta to speak to this specific matter of, you know, what is missing so that we can actually implement the provisions of Act 159.
So as was mentioned in my presentation earlier, is that a non-conviction arrest record lies with the Department of Attorney General's office. Once that's expunged, the Judiciary needs notice of that and information that it has been expunged in order for us to seal the court record. And so with Act 159, you know, currently it is with the petitioner, the defendant, to inform us of the expungement. Come July 1st, 2025, according to Act 159, the information would need to come to the Judiciary, be transmitted to the Judiciary with the court case number. So once that's done, we're able to do the sealing. So I think that's what's, you know, if Department Attorney General is saying that there needs to be a statutory amendment in order for them to release that information directly to the Judiciary, then we're able to work with that. We can do it at this point to seal, but really on our end, we just need to know when the arrest record has been expunged.
Okay, thanks very much. I should ask other members if you want to jump in with questions. We'll go first to Vice Chair Takayama.
Yes, thank you all for your presentations. I have a question, if you could clarify it in my own mind. And it's if someone was convicted of, say, a theft, and went through the expungement process successfully, his record was expunged, and he then decides to apply to become a police officer. And on the job application, it says, have you ever been convicted of a crime? Is his correct answer no, or is it yes, but it was expunged?
Who would like to take that question?
On the certificate that the individual receives for an expungement, not a result, well, in a conviction as well, if we get the court order, it states that a person can actually say no. I'm not sure what the application, the police department's application says, if you've been arrested, convicted, or expunged of any information, if they actually ask for expungement, I don't know. But our certificate and the information we provide to the individual is, you can respond without any repercussions as no. I have not been arrested for any offense
Okay.
of that, right? So,
right. Okay, so to take it another step, suppose this person didn't apply to become a police officer, but say applied for a private job to work at Long's Drugs or whatever, asked the same question, and replied, no, never. And Long's uses this third-party app to search for criminal history, and I think Jennifer mentioned it as well as you, Ms. Acosta, in your presentation. And they find out that, well, this person actually still has this conviction because, as I understand it, their records are not expunged, right? Is there anything to require, well, two parts. Is there anything to require this third-party website to expunge as well? I assume not. And secondly, is this applicant probably in trouble for answering the way he or she did?
are you asking Judiciary?
Anyone.
We have received requests from people that say that they've had their information expunged and that it's showing up on the websites. We don't have any control of that. The state of Hawaii doesn't sell criminal history information to a third party. Let me make that quite clear. We don't sell that information. Now, where these parties are getting the information, I don't know. Recently, we had a media outlet wanting to confirm that the certificate that they received from an individual saying they got their record expunged, they just wanted to verify that it was in fact true. We couldn't divulge that information. That information is confidential. So to say that they would get in trouble, I go back by statute. They can actually say, no, I have no arrest record for a specific charge, right? But if they have other ones that aren't expunged, then I would hope that they would divulge that. But I need to make sure that everybody's clear that Long's and grocery stores, they don't have the authorization to get arrest information. Arrest information is not public record for public view, only 5 different entities as well as law enforcement. So conviction information, right, you just go to eCourt Kukua, you can look up the person's name and you can see that information.
So
Let's go, if we could ask a couple of people to respond. We can go first to Mr. Stiefel and then to Mr. Roberts.
Yeah, I mean, I was just going to say, I don't think Phil is taking enough credit for best practice that Hawaii has in the expungement certificate. You know, the fact that an individual would have an expungement certificate would prove, right, that record has been expunged and would allow that individual, even if that person's record came up through a third-party database, that they would have that certificate and show that employer, hey, I have a certificate from the Department of the Attorney General that proves that my record was eligible and got expunged, right? So that is actually a really great best practice to highlight for Hawaii in the fact that that certificate exists and kind of ensures that issues like that can be addressed by that individual.
Thank you, Mr. Roberts.
I was going to say the same thing. I think it's critical you have the certificate that you can present. It nevertheless is going to be a little bit of a disconnect if you've said you have no record and they say, well, we found. Part of the other challenge is simply having all of the consumer reporting agencies, CRAs broadly, accessing this data. We've seen lots of states where the state, I don't know if Hawaii does, but the state court system sells access to court records. Those are public records, and they sell that to companies like LexisNexis and Checker and a variety of others. Pennsylvania Administrative Office of the Pennsylvania Courts has done a really brilliant job. They have a life cycle file. So every time there is a record to seal or expunge, it's recorded in this life cycle file. Every vendor who purchases the court data from the Administrative Office of the Pennsylvania Courts has to agree to make sure that all of that data is uploaded and that those records are sealed from their systems as well. And Administrative Office of Pennsylvania Courts routinely audits those vendors to make sure that, in fact, they are sealing those private records. And if they're not, they're not going to be able to have access to the court data. But having some kind of provision that says that all of the private holders of this data also have to comply with state orders to seal or expunge the records is important. Having an enforcement mechanism becomes a challenge.
So
Please, go ahead.
for the judiciary, it's not sold to private vendors, but before it's expunged or sealed, it is public information. So as third parties are scraping information off of these public, what's open to the public, we don't really have control over that at this point. Again, once it's sealed, then it's sealed. But if that information was obtained at the point that it was public information and it remains out there in the internet universe, that is something that is beyond the control of the courts at this time.
So, in the case of a private company like Long's, I'm sorry to pick on Long's, but what's to stop them from saying, fine, you have this expungement paper, we're not hiring you because you still have this, you were convicted of a theft. Is there any law protecting the applicant from being that, from having that held against him?
Not that I'm aware of.
I'm not
Well,
aware of.
maybe I could ask someone else who is here who knows a lot about these things. Carrie Ann Shirota, if you could join us at the table. Carrie Ann Shirota is with the American Civil Liberties Union, who's been experienced in these things and has worked in this area. Appreciate you being here and willing to jump in and help us answer the question.
Aloha, Representative. Thank you. I was raising my hand. So I am currently the policy director for the ACLU of Hawaii, but I previously worked as an enforcement attorney for the Hawaii Civil Rights Commission. And so truly I would like to defer, but they're not here. And I just want to point out we have Hawaii Revised Statute 378, which is considered our fair employment laws, which explicitly includes arrests and court records. Now, it's I wouldn't say totally complex, but essentially we were the first state to ban the box compared to any other states, recognizing that we want people to have opportunities for rehabilitation and to get a job. And so that currently exists. So to answer your question, if someone has an expungement, they are allowed by law to say, I don't have a criminal record. However, there are other ways that Long's Drugs, not to pick on Long's as well, but having worked there previously in 1 year, the largest number of complaints that were filed 1 year were people who were being discriminated on the basis of arrest and court record. And so the reality is such that sometimes employers are relying upon third parties, and the records are not always accurate. I can think of one gentleman who was arrested for, actually it was I think it may have been an attempted murder, and he was like 18, 19 years old. It went to trial, he was not convicted. But that came back to haunt him, because you could plug in his name in a Google search, newspaper articles came up. He was trying to do the best that he could. He was trying to apply for another job to get a higher wage, and this kept coming back. To add to the complication of that, he then tried to say, first of all, I was not convicted, and when he tried to go back, he went to the expungement clinic and they helped him. But there were also records, there were some other charges on his record. It was not him. Somebody else gave his name when they were arrested, And he kept trying to challenge it. And only when he got other attorneys and assistants involved, thankfully, to help him, showed that it was not him. And he had to pay to, I think, get copies of his fingerprints to prove he was not that person. The person was like of a different race. There was about a 6-inch height difference. That's just one example. I can think of another client who actually did work for a entity, had been hired, working there successfully, was encouraged to apply for a supervisor position. Then when they ran the background check, for some reason, this record popped up, and she did not get the job, and she actually was terminated from her position. So even though someone can file a complaint for free with the Hawaii Civil Rights Commission, that requires knowledge that this exists in law, and even so, that process takes a while to investigate and potentially litigate or resolve. And so I think there is some gaps here that we need to really look at the bigger system.
So to carry that a step further, this person who was discharged or this person who was denied a job, would he have cause of action against Longs for denying?
Potentially, yes. If they
denied-
file a complaint with the Hawaii Civil Rights Commission, they could then have an investigation. The employers could decide to settle, or if they don't settle, and the executive director looks at the investigation and determines there's cause, that they can move the case over to the enforcement attorney side, and the enforcement attorneys will litigate the case on their behalf and on behalf of the community, because we all have an interest in people having opportunities and not be discriminated on the basis of arrest.
So you said there have been a number of cases.
There have been a number of
and
cases.
Have the complaints been upheld? by
Yes,
the
there's been a
commission?
number of cases that have been settled through that process, but that is assuming that people know about it.
Thank you, Chair.
Sure. Representative Miyake, do you have any questions, or I can? No. Okay, let me just ask Michelle, is it true that arrest records are not on eCourt Kokua?
The arrest records in terms of the documents itself?
Or that if an employer, because eCourt Kokua is a publicly facing database, so an employer who is reviewing somebody who's applying for a job, they'd go there. Would they be able to see an arrest if the individual who's the applicant was arrested at any point? Is that available on eCourt Kokua?
When you search on eCourt Kokua, there may be a reference on the public-facing side to the arrest or the citation number. What is on there is a document. If you get the access to the document of the complaint, it'll have information as to what the charges are and what the alleged violations are. But are you asking what the arrest documents as far as fingerprinting,
No, not that,
photos?
but
No.
just that there was one, the existence of an
Correct.
arrest.
Yeah.
That would be on eCourt Kokua.
If there was a criminal complaint against that person, it would have been initiated through an arrest.
Okay, all right. Let's turn our attention to 7/12/1249, if we could now. So this one, in 2019, the legislature decriminalized 3 grams of cannabis. Now, there were people who have been, that were convicted for that offense, and it's no longer a criminal offense now. So is there a difference between how arrests that have the charge code for HRS 7/12/1249, how do they look in your database prior to 2019 versus how they look now, given that cannabis possession was decriminalized in 2019? I guess that's for you, Mr. Higdon.
Well, the charges, I mean, it'll show 7/12/1249. There may be subsections as well. The numbers that we provided, and I think that Frank may have provided and Dave talked about, that was it was an estimate a couple months ago. The numbers that were provided today included some subsections as well, I think. Is that not correct, Wendy? I'm referring to my staff that actually pulled these numbers, sir.
So 7/12/1249 is, it actually refers to not just the 3 grams of cannabis, it includes other controlled substances.
Other controlled substances.
And so would the database disaggregate between and identify whether the individual who had that offense was in possession of cannabis as opposed to the other controlled substances? Can we disaggregate that data?
It's not reliable because that information is optional to provide to us. Some of the law enforcement agencies indicate in the reports that we receive, the information, the amount of drugs, what type of drug it was. So it's not reliable. So to know exactly what the drug was and how much the quantity was, a lot of times we would have to go to the law enforcement agency and actually ask for those reports, or for the prosecutor's office, because the charges may be amended. Somebody might be charged and arrested for a larger amount, but it's the charge is amended of some sort. So
Okay.
I know I spoke of this before, but certain information that received is optional, and some information that we receive is mandatory. The statute is very broad. It just says arrest information.
So maybe I could ask either Jennifer Brown or Frank Stiefel, what would be the best way for us to move forward to create some sort of state-initiated process to clear the records of those who have a record of having been convicted of an offense that is no longer criminal? And in this specific regard, 3 grams of cannabis. How do we proceed on this? Do you have any Frank, you want to start first?
Yeah,
Okay.
so I think, unfortunately, it sounds like, Phil and the ACJDC is going to have to follow the breadcrumbs and go back to the police departments to figure out if that arrest record was for cannabis. I'm not sure. The way in which 1595 was written is actually to address this issue, which Phil had raised prior, because of how it becomes much more of a cumbersome process, right? And because of the fact that, according to what Phil's saying and the ACJDC is saying, is that those arrest records under 1249 do not specifically say whether it's for cannabis or not. So what it would require of the ACJDC is to talk with those police departments, follow the breadcrumbs, and figure out from that police department who had made the arrest whether or not cannabis was involved in the arrest. I will also say, I think there could actually be some coordination with the judiciary. As Dave had highlighted, the judiciary has some of the most comprehensive disposition reports in the country. And so my assumption would be that there would be some information on those disposition reports, notes from prosecutors related to whether or not cannabis was involved in that arrest. And so I would love to hear more information about if that is correct, or what information would be included, but I think that's how it would be initiated, right? Is a lot of, some work would have to be done by the ACJDC in coordination with the judiciary and the police departments to figure out which of those records do qualify.
Maybe we could hear from Jennifer and then from Michelle. Go ahead, Jennifer.
Yeah, I was just going to add to, I think that was, when this passed, I think that was a big issue that was brought up by the public defenders as well, was that, especially because it's 3 grams, and they said it a lot of times in cannabis, misdemeanor cannabis charges, that there is no amount, it's not weighted, especially if it's like residue or something. So it almost would be, does that require judge intervention to make a factual finding of that amount? So that could also kind of complicate it. At least if you could quell from the records what's cannabis and what is not, then I guess the other question too is does it fall within that threshold for the older cases, right?
Okay. Let's go to Michelle first and then back to you, Frank.
Yeah, so I think that's the complication, is that if you look at the charging instruments, if they do distinguish what it is, if it's cannabis, I took a look at a few and I did not distinguish what type of substance it was. And also, at that time, before it was decriminalized, the volume of the substance was not indicated. So I can't say that that's for all the records. I don't know that they were measuring for 3 grams or less than 3 grams, but as, it could have also been the charge was lessened. So at this point, it is difficult to retroactively take a look at what is eligible under 712-1249 at this point.
Let's follow up on this before we switch subjects. Go ahead.
So I was just going to say that the language in the bill
This is, you're referring to House Bill
1590
1595.
Correct,
Which,
correct.
just so people know, we moved it out of the Judiciary and Hawaiian Affairs Committee. It's placed on the calendar for now third reading in the House. If we're able to get enough votes in support of it, then it'll be passed by the House over and cross over to the Senate for their consideration. And this bill creates a state-initiated process to expunge records of arrests and convictions for the offense of promoting a detrimental drug in the third degree. That's what we're referring to as 712-1249. And this expungement of records would be at no cost to the record holder, and it requires the Hawaii Criminal Justice Data Center, which we've been calling HCJDC, to submit biannual reports to the legislature until all eligible records are expunged. So that's what this bill refers to. So back to you, Frank.
Yeah, so the reason why the reason why the language looks as it does for this bill is because of the issues that the ACJDC and the Judiciary have brought up, right? So it's presuming relief based on the lack of information that exists currently in Hawaii's criminal record repository, right? And this type of a fix and presuming that relief is not unique. This is something that Rhode Island actually did for a state-initiated record clearance process for cannabis records. Other states have done this, so I would not say that this is a unique fix to this problem. This is a problem that has existed in many states, and this is why the language is that way, is to presume relief given the lack of data that exists and can specify whether or not these are for cannabis possession charges and offenses or not. The other piece I just want to highlight here is, and I could be wrong, so Phil, correct me, but out of those 50,000 records, is it 40,000 are for non-convictions, or what is the amount that are for non-convictions of 1249? Because so this
I'm sorry.
out of for 12 under 1249 there is around 50,000
Correct.
Arrest records.
And within that, there was 10,000 convictions.
So would
Correct.
so my presumption would be that 40,000 would be for non-convictions.
Correct.
So this type of the need to know whether it's for cannabis or not for those 40,000 should not be an issue. They're for non-convictions. People have not been convicted of no criminal wrongdoing. So the overwhelming majority of these records are for non-convictions. So this issue, as far as trying to figure out if it's for cannabis possession or not, as opposed to another substance, should not be an issue as far as clearing these eligible records, if that makes sense.
That's a very good point. So let's just think about those who have non-convictions. Would the Attorney General in your office be able to, at HCJDC, would your office need people to fill out a form identifying themselves as having this record if you've already identified who they are and that there's no conviction?
Right. So as it stands right now, we're required, if an expungement is granted, to obtain the photographs, fingerprints of that arrest and send it to the individual with a expungement certificate. And that's why it's so important that an application be filled out, because it would be, we would be doing our part by sending that information to the last known address, because people move around. So right now, we're required to send that certificate and that information to that individual. So I don't know if that answered your question or not.
It just makes it challenging very
Yes,
much.
sir.
Mr. Roberts, what's experience in other states? I mean, how this is handled?
One of the things that we talked to Washington State, they were looking at having the Washington State Patrol for a it was a vacatur of convictions. And we're asking the State Patrol, under a suggested provision, to notify people that they were eligible and to pre-populate a petition for them if they were eligible. The problem is the notice to the people. And as Phil said, we don't know where they live. We have no ability to contact folks. Our recommendation to Washington was, if you're going to do it, set up a website, set up a massive billboard and kind of the social media campaign that Frank was talking about earlier, to reach out to folks, to say, we have this program. If you want to check and see whether you are eligible, fill out this online form and submit the online form to us. You have to have some identity verification there so that I'm not putting in Ms. Acosta's name to find out if she has a record and pretending to be her. But there is a way, I think, to notify people and say, this is you're eligible, and this program is available, and if you think you're eligible, send us your name, and we'll do the research, and if you are, then we now have a way of contacting you, at least an email address to contact the person to let them know that the record has been sealed.
Okay. Jennifer, did you, in your presentation, you talked about the need for public outreach.
Right.
Does this fit into it?
Yeah, when we did the clinic, we did morning radio, we had a whole website dedicated to it so people could get the information, and then also, you know, a web form for them to fill it out, and then we pre-screen them, basically. So, I mean, I think that technology is there, that, you know, this is something that somebody could fill out their information, you know, contact information on a web form. I mean, I think that makes it easier than the paper
Right.
application, right? And I don't know, I mean, I know the court has a notification for court dates now, they have a notification, so I don't know if that could be something that could also be beneficial to use.
First to you, Dave, and then over to Michelle. Go ahead.
Sure. The other component that is really critical that Frank was just bringing up is these are for non-conviction records. I mean, if the vast majorities are non-conviction, then that information should not be released to the public, broadly available to folks. Obviously, you can look at court dates to find out when a case is scheduled to appear in court, and that is going to continue to be an open record. But the broad spectrum of these records, if they don't have a conviction, that information shouldn't be out. And you should be able to, the state should be able to act on that directly. And if the person wants a certificate to demonstrate that in fact they were not convicted and the record has been expunged, then provide the ability to do that. But there are a number of states who are saying, with these records that do not have a conviction, where there's a complete exoneration, it was a mistaken identity, it was dismissed with prejudice, then those records should be cleared.
And not available for public viewing.
And not available for public viewing.
What would you need at Judiciary to be able to accomplish that?
Well, you know, if this is initiated through Department of Attorney General's office, and this second step is to seal the court record, if there is a court record, then we would need to, depending on the 40,000 and how quickly that comes through, I mean, we could do that process. Again, we just need to know once they are expunged, the court needs that information so that we can then take that step of sealing.
So back to you, Phil. And I'll come to you, Frank.
Yeah, no, you're good, you're good.
Back to you, Phil.
I might have a solution.
So those 40,000 non-convictions, the goal being, as Mr. Roberts was saying, is just to, even without the petition from the individual, we just want to make sure that that no longer is publicly viewable. So how could we go about accomplishing that?
Well, that information in non-conviction is not publicly available.
Okay.
Right? So it's still, you're still going to have to look at the individual's record, because we have to have a final disposition, because there may be a case going through the system that hasn't been updated by law enforcement, the prosecutors, or judiciary, for whatever reason. So we're just not going to blanketly say that when we look into the system and just say John Doe, and there's no disposition, it doesn't matter, we're just going to expunge it, because we wouldn't be doing our due diligence. Because just for the fact that this case may be moving for whatever reason, for whatever purpose, and they may have already been convicted and it hadn't got to the point where it's been updated yet. So I would be reluctant to say we're just going to wipe all these away. We're still going to have somebody actually go in and determine what the final disposition is. Now, if it's an old case and it says not guilty or no further investigation, those are easy. We can expunge those. But when there's dispositions missing, that's the issue.
That's more difficult. So
Yes.
So for the easy cases, can you take action on those now?
Well, we can look at them, but we're still required to have all this application, and we're
Right, but
still required,
I'm wondering, what would you need in terms of statutory authority to be able to do a state-initiated process so you don't have to have the application? If it's clear in your records that as you were just saying, it's clear, it's easy,
Right.
we can do it.
Well, if we have the statutory authority, we can do it, but it's not going to be automatic, as I think
we're
everybody
not-
understands,
I'm not
right?
using the
No, I
automatic
mean,
word.
I mean, it's going to take it takes time, right?
So could you provide us with with the language, what the statutory authority would need to be to allow you to do that? I mean, not right now, but,
Sure.
because I'm eager to figure out how we can move forward. Let's, how they say it, pick the low-hanging fruit, Let's
Right.
try to do that first, so we get some practice. And then we'll figure out how to deal with the more difficult ones.
Right.
And you may need more support. I understand there's, folks that are willing to assist, but like you said, they don't have the authority to
Right.
look because it's confidential information.
It can be done. I think we do it in steps. I think that the low-hanging fruit first. I'm surprised Sean hasn't already prepared something to change the statute.
Well, you can help us out.
He'll help us out, I have no doubt.
Yeah, Sean will help us out, but you can help him.
But it's doable. It's going to create, I brought this up, it's going to create somewhat of a hardship on us financially. But I understand what is being asked, so I'm not sitting there just saying no.
Oh, I understand.
Right.
And if you think that you're going to need some additional financial support, tell us so
Right.
that we can figure out what we need to do. Because clearly, I mean, who was saying, there's a financial note? I think you were saying that, Frank, where we know that there may be a cost to this.
Yes.
Yeah, no, there's
But
no
to look, these are people's lives, and we're trying to give them back their lives and give them a chance at redemption. So there's a public value to spending this public money. So ask if you need that kind of support.
Well, I think this meeting is very important because everybody's understanding all the issues that we're facing, right? So I believe a bill's going through right now as far as a task force, and I think that's a good idea.
And before I go to Frank next, I just want to say that Senate Bill 2706, which has been heard in the Senate, my understanding is that their latest version of that bill, which is the Clean Slate Bill, the latest version is to establish a Clean Slate expungement task force to develop a state-initiated record clearing program, and then requiring the task force to submit reports to the legislature.
And I think that's a good idea. I think that's the direction we need to take instead of just saying we're automatically going to do this and you got to have this end date. I think the groups, the people need to get together and say, how do we hash this out and make these changes?
Okay, over to you, Frank. You've been dying to
So
say
Phil,
something. Go
so
ahead.
Phil, I do have an answer of the statutory authority we give you through HB 1595. I do actually think that bill would provide you with the statutory authority that you need. I hear you on some of the issues as far as an end date, and what I would say to you is, and I think I provided in some of the state examples, is we can have a start date, right, and quarterly reports, but we don't need to have a due date, right? And I think when you look at some of these states and the implementation start date for when a state-initiated process could begin, you could have it begin in 2 or 3 years, which would give you enough time to build up the capacity and the infrastructure to implement said state-initiated process. And then the other piece of it is related to the certificate, which I totally hear you on the issue of being able to provide a certificate without proper contact information. It's pretty straightforward. What HB 1595 does, though, is that it requires an individual to opt into receiving a certificate. So it doesn't place the burden on the Department of the Attorney General to send those certificates unless an individual opts into that process and provides that contact information for the ACJDC.
So that's what we currently is in the House Bill
Yes,
1595.
correct,
Yeah.
correct.
So we're trying to make it easier.
Yeah.
So that you don't have that requirement to send the certificate, so that hopefully would make it less necessary to have the address.
Correct.
Yeah, so that's what I'm hoping. Mr. Roberts, do you have some comments on this after your experience with other states?
One last kind of comment. What I would suggest is, if you're going to do it in tranches. So create tranches of candidates who are eligible, and look at those folks who have a single eligible offense that we're talking about here, and that is the 712, right? So if they've got a single, the only reason I'm saying is if you do it in kind of a coordinated, stepwise fashion, if they only have a single adjudication or single arrest with clearly a non-conviction adjudication, those are the simplest, right?
Okay.
And that clears the entire record. That's the real benefit, is it clears the entire record for that person.
yeah.
And then look at the ones that, where it's an open arrest and you don't have a disposition, and how long has it been, and are there some deferral of prosecution pending supervision or something like that? That might be a second stage. And third is looking at folks who've got that adjudication, but they have other convictions that will still remain. And so it's only going to be a partial. Those are probably lowest, you know, not to say you shouldn't do it, but they're not the ones you ought to spend your immediate time and resources on.
Yeah, okay. We need to start to wrap up, but I want to give everybody a chance to have some final words about, and maybe I could prompt them, you know, how can the legislature help you effectuate a state-initiated process that we can move forward with? So maybe let me start with Phil, and then I'll come to Michelle, and then I'll ask David, and then we'll go to Frank, and then to Jen. So Phil, go ahead.
Well, I think that if the bill that was going through the Senate, as far as the task force, is the right and the first step that we should do, that just for us to get together, hash everything out, let everybody know the limitations we have or the things we struggle with, and how do we work with that. And that deadlines, hard deadlines, are not placed upon the judiciary or the Attorney General's office to say you shall have this done at this time. Because there's other things going on with judiciary as far as IT, there's a lot of programs going on with us. So we have to fit all that into the system. And not to say that this takes precedence over this, because I understand the importance of what we're trying to do here and accomplish. But I think we're on the right track if this task force is actually formed. I think that's the way to go about it, sir.
Well, I'm hoping to move both HB 1595 and Senate Bill 2706 forward so that we can give you the authority to provide the information to judiciary and for a state-initiated process, but also set up this task force. Before we move on to questions, I failed to ask Vice Chair Takayama to ask his question, and then we'll continue with the
I'll
final
apologize in
statements.
advance for what might be a dumb question. But a few years ago, the legislature enacted a law that raised the felony threshold for theft to $750. So in other words, if people who stole $750 worth of merchandise or above, that became a Class C felony. Before that, the threshold was $250. So do people who were convicted of a felony for stealing more than $250 but less than $750 have a case for expunging their records of a felony which is no longer a felony?
I think judiciary is going to have to answer that.
Michelle,
I'm going to call Ms. Jenna Wong to help with that.
if you could introduce yourself, and let's get another chair for, could you? Sorry. No, Reese here. Oh, you're very kind. Thank you. Please introduce yourself and proceed.
Jennifer Wong, the staff attorney for the criminal divisions. In that instance, even today, they would be guilty of a lesser offense, so there would still be a conviction. It's not no longer, like in the case of the cannabis, it would be a violation now, so there's no conviction. I think that's the biggest difference. So they would not have an ability here.
Okay, thank you.
Unless we're talking about the first-time property offender, which you guys are also working on. So that may be an option, but that's an expungement of a conviction as well, not arrest records.
Okay, thank you. Okay, so let's go back to the final question everyone could comment on. You know, our desire, as you can tell here, is to set up some sort of state-initiated process for expungement for, qualified individuals. What can we do to help you be able to do that?
So, Chair, I think what we've demonstrated here is it's a very complex issue, and we all hold records in various places, official records and non-official records that are out there. I do echo Phil's support of a task force, and I think coming together of all the internal and external stakeholders in this process is a very good step forward in really hashing out a lot of these issues that are housed in our various agencies. So I think that is the best way forward and being able to go through a thoughtful process that will meet the needs and desires of the community.
Very good. Thanks very much. Mr. Roberts, if you want to comment next.
Very quickly, I completely agree with the approach that's being taken with 1595 in terms of identifying particularly those records with non-convictions and providing some provision for records relief from that. Do it in the stepwise fashion I was talking about so that you can have the greatest impact. A task force looking at records relief broadly, looking at the entire enterprise across Hawaii of all the different elements that go into it, and building on some of the practices and lessons learned from other states. You may even want to expand the range of records relief that's available to you based on the experience of some other states.
Very good. Well, we'll come back to you for advice on that. Frank, you want to give me comments, and then we'll go to Jen.
Yeah, just really quickly. So I think, I mean, in my mind, it would make it's a both-and approach, right? So I think it makes sense to pass and to enact HB 1595. Like I had mentioned before, you can have language that creates a start date for that process and negotiate with the ACJC, the Department of the Attorney General, to figure out the best time to begin that process, to have a ramping up period for infrastructure and capacity to be there to successfully implement it. I would say that it seems like a lot of the work has already been done in the identification of those records, right? So, and it also provides Hawaii with a unique opportunity to pilot what a state-initiated process can look like, to identify pain points, troubleshooting that can inform the task force of what a broader record clearance relief process could look like. And, you know, we're talking about roughly 30,000 individuals who have a record under 1249. So we're talking about thousands of individuals who have a criminal record for something that's been decriminalized since 2019. So the fact that someone would need to wait for a task force to determine if those records should be expunged, I think is unnecessary, to say the least.
Okay, great. And Jennifer, you get the final word.
Well, I would echo a lot of what he said, but I do think if doing a task force, it should be more broad. Like, we know that the records don't seem to be talking to each other. The charges are coded differently depending on whose system. You know, there's probably a more sufficient way to do, you know, these databases going forward. So I think, you know, having the ability to have a task force that's not just saying, okay, what do we do with the records we know we have now, but also going forward, especially with the potential of other clean slate bills getting passed later down the road as well.
Well, very good. Well, this has been very educational. I want to thank all of you. I want Phil Higdon, Administrator of the Hawaii Criminal Justice Data Center. Thank you. David Roberts, Executive Director, System for the Electronic Analysis and Retrieval of Criminal Histories. Thank you very much. Michelle Acosta, Deputy Chief Court Administrator for the First Circuit. Thank you very much. Jennifer Brown, Associate Director, Staff Attorney for Hawaii Innocence Project. Thank you. And Frank Stiefel, Senior Policy Associate, Last Prisoner Project. You have all been very helpful, candid. We're allies together in this. This committee is committed to trying to figure out a path forward that will achieve our goals. So I appreciate your time spent. All of you who are in the room here listening, I appreciate you being here as well. Members, I appreciate you being here. Staff, thanks for making this happen. And with that, our information meeting is now adjourned.